Joining us now, senior legal affairs reporter for Politico, Kyle Cheney, criminal defense attorney and former federal prosecutor Duncan Levin, and former district court judge Shira Scheindlin. And then we also have our justice and intelligence correspondent, Ken Dilanian. So, Ken, let me start with you. Once again, U.S. Attorney Lindsay Halligan was the only one to sign this indictment. Again, what do we know about how this came together?
Yeah, that's right, Anna. That's our reporting. She was alone in the grand jury room, and she presented yesterday for the first time this case to a new grand jury. That is also our understanding from sources. And it just speaks to the unusual nature of how this case has been presented, very similar to the way the case against former FBI Director James Comey was presented. Apparently no line attorney in the Eastern District of Virginia, no career prosecutor willing to go forward with this case after the former U.S. attorney had rejected this case and said there wasn't enough evidence to bring it, and then was subsequently forced out of office. So you have Donald Trump's handpicked U.S. attorney, Lindsay Halligan, bringing this case to the grand jury after Mr. Trump ordered, essentially, the Attorney General of the United States to move forward with this prosecution. Now, what's interesting here is this is a different case than the one we thought would come against Tish James, because it's not mentioned in the criminal referral by the head of the Housing Finance Corporation, Bill Pulte. This is a different property purchased in Norfolk. Essentially, the crime here, as alleged in the indictment, is that she purchased a home that she said was going to be essentially a second home, a vacation home, but instead used it as a rental property. And the benefit that she got from that was 0.8 of a point on an interest rate. So instead of a 3.8% interest rate, the indictment alleges she got a 3% interest rate. And the indictment says the entirety of the ill-gotten gains, the alleged ill-gotten gains from that, would be less than $19,000. And for that, she's facing two charges, one of which is bank fraud, which carries a maximum penalty of 30 years in prison. So a very serious prosecution brought for what looks like a technical violation. And there's really no evidence in the indictment that suggests that they can prove that she had criminal intent. That's what this case is going to hinge on. Did she knowingly deceive the banks, or was this a mistake? Was this inadvertent? There are many possible explanations. We'll have to wait and see what the evidence is on it.
Kyle, what do these rapid-fire prosecutions of first Comey, now James, tell you?
I mean, look, even if there was some merit to the prosecution, disentangling it from President Trump's essentially explicit order to bring these prosecutions is going to be, you know, to me, it seemed unlikely these cases will ever go to trial, because that's what they'll be fought on in court is were these selective prosecutions. It's very hard to bring a selective prosecution case. Those are very difficult claims to prove. But here you have it laid out there on Truth Social, with the president saying we need these indictments now, and then he gets them. He picks the prosecutor to bring them, and then he gets the indictments, within 3 weeks. So there's so many shoes to drop on selective prosecution issues before this case can ever go to trial, and separating what President Trump said from the actual potential merit of any of these cases is going to be very challenging for prosecutors.
Duncan, the charges are bank fraud and making false statements to a financial institution. What must the government prove?
Well, it's a pretty simple case. What they have to prove at the end of the day is that she actually did that, but also that there was an intent to make some money from doing it, that there was some sort of criminal intent in doing it. And that's the fundamental weakness of what is a pretty straightforward case, that she actually intended to get this $19,000 benefit by cheating and lying on a bank form that she filled out wrong.
My understanding is she actually filed that in her taxes.
Yeah, I think it was all pretty open, and I think that they're going to have a very hard time proving that. And that's why you don't see any line prosecutors who are willing to sign their name on the prosecution itself or on the indictment. But before you ever even get there, she's got some core constitutional issues that she'll be able to get in front of the judge. One is this idea of vindictive prosecution. The other is there's a doctrine called outrageous government conduct, where even if it's true, even if what she did was true, the judge could still dismiss it because the prosecution's so laden with bias, with political motivation, that it offends the core notion of fundamental due process, substantive due process under the Constitution. And so before we ever even get into a courtroom and a jury's ever deciding whether there's intent or not intent, I think the judge is going to get a good crack at dismissing this case on a very, very, what I think is a strong selective prosecution case and a violation of her constitutional rights.
Judge Scheindlin, based on what you have seen so far, does this case appear to reach that burden of proof?
It's a difficult question because there's almost no precedence. Judges have had these motions made to them, but almost never are they granted. This case might be the one exception where a judge actually could grant a motion to dismiss for selective or vindictive prosecution because of the statements that President Trump made before the indictment and after the indictment. He's been so clear that he directed his Justice Department to indict these people now. And the way he has described Letitia James, or the way he described James Comey, shows that his animus is the reason these cases were brought. Frankly, no federal prosecutor would have brought a case for this small amount of money without any proof of intent or plan or scheme to defraud, even if it's accurate that she said it would be a second home, but instead it's a rental home. And she did disclose on her tax return that she didn't spend any time there. She was very clear that it became a rental property. And remember, this wasn't the original property we were being told about where there was confusion of first home, second home. This is a very different case.
And Judge, we actually checked into how common these cases are, and we found in the most recent data less than 60 federal convictions of this type in a whole year across the country. A conviction we know can carry up to 30 years behind bars. Is that likely here? What are the key questions a judge needs to ask?
Well, as I said, the first thing the judge is going to do is consider the motions to dismiss. Now, this judge is a pretty darn new judge. He's been on the bench only 2 years. He's 39 years old. He was a federal prosecutor. He was a law clerk to a federal judge, but he hasn't had a lot of experience in trial work. So as a judge, so we'll see, because dismissing the case would be a very strong statement, so to speak, and it could be appealed. There would be no double jeopardy at that point because jeopardy would not attach. So even if he dismissed it, it would be reviewed by an appellate court. So it's a long road between now and a potential trial.
Duncan, how significant is it that it was, again, just Lindsay Halligan, the new interim U.S. attorney in this office, who signed the indictment? I
think it helps Letitia James actually make out her case that this was vindictive prosecution. The fact that no one is willing to do it, not that that's admissible at a trial, but I think the judge will take note of it. And I think it's just devastating for morale of everybody who's at the Department of Justice right now, the career prosecutors who are there, who are watching their offices get gutted, who are watching, a new U.S. attorney come in who not only has no experience with criminal law at all. She's an insurance attorney. She's got no experience ever having presented a case to a grand jury. She was in there alone doing this for the first time. I think it just speaks volumes to what is going on here, and it's patently obvious on its face that this is something that is not enjoying the deep support of people who have done this for their careers. And it's just demoralizing to everybody who are really great public servants who still work in government service.
Kyle, Trump ally, the Federal Housing Finance Agency Director Bill Pulte, has appeared to target the president's political foes while look the other way when it comes to some of his allies. He was asked on CNBC last month about mortgage fraud allegations against Texas Attorney General Ken Paxton. Take a listen.
Public officials shouldn't be exempt from scrutiny.
Speaking of that, Ken Paxton, Texas Attorney General, running for U.S. Senator, the U.S. Senate, there's at least, it looks like, 3 examples, working examples right now of what could be described as alleged mortgage fraud. Is that something you're looking at?
As I said, unless it's something that's either been made public by lawyers like Norm Eisen or in criminal referrals, I'm not going to comment on any specific situation. If things are made public, then or if we decide to make them public, then I will talk about it. But I'm not going to engage in any
make them
specific
public
individuals.
if you made this public?
That's false.
So that conversation happened, Kyle, after Lisa Cook was targeted by the Trump administration when the president tried to force her out of her role as the Fed governor, as one of the board of governors, over these allegations of mortgage fraud. It's the same allegation of mortgage fraud facing the Adam Schiff investigation in a different district. It's the same thing now with Letitia James. Have we seen any Trump allies face similar scrutiny?
I mean, at least, again, in the public statements, we haven't, and that's tailor-made. You can just plug that right into the selective prosecution filing for Letitia James or James Comey, essentially. But, when you, particularly in Letitia James' situation, she gets to say, look, There is allegations floating out there against political allies of the president, and we don't see them being treated the same way. And that's how you prove a selective prosecution motion. Again, very hard thing to prove, but if you show that similarly situated people are not facing the same kind of prosecutorial scrutiny, that's how you win that argument.
Judge, we know James Comey's team plans to challenge Halligan's eligibility as U.S. Attorney of the Eastern District of Virginia. Could that case end up affecting James' case?
No, it won't affect her because of the statute of limitations. So there's 120 days for an interim U.S. attorney to be in place. And the question is whether you can have a successive 120 days for the next U.S. attorney to be in place. One court in New Jersey has already ruled you can't. So potentially her signing this indictment throws it out. Now, in James Comey's case, that would end it because the 5-year statute of limitation would have run and they couldn't re-indict him in front of a new grand jury. But because these charges have a 10-year statute of limitations, even if a judge were to say that she could not sign this because she was not appropriately acting as interim U.S. attorney, they could bring it again before a different grand jury and try to get an indictment again.